the matter of the suspension, and whether there is something to worry about. I've heard constitutional crisis, the president should have been cautious, this is poisonous and acidic, among others. Lawyer, thank you very much for your time. Good morning to you.
Good morning.
I hope you're well.
Good. My God's great.
Okay. And it's great to speak to you this morning. First, I know you've seen that communication from the Jubilee House. Do you find anything wrong with the approach?
Which communication are you talking about?
A communication indicating that a prima facie case has been established against the Chief Justice, a committee set up, and a warrant issued for her suspension.
So now your question.
So I'm asking whether you find anything wrong with that whole communication. There are people who have no problem with a prima facie case being established, a committee being set up. They have a problem with the Chief Justice being suspended. There are those who have a problem with everything that has been done. They think that the law is just there. Don't go there at all. Does any of these opinions hold sway for you?
No, it doesn't. None of them hold sway for me, if you ask me. You see, sometimes we just have to be consistent with our choices and our life. We have chosen a constitution for ourselves. For me, the cardinal question to ask at this point is whether anything being done is consistent or otherwise with the constitution that we have chosen for ourselves. If the answer is yes, it doesn't matter what idiosyncratic feelings of the gravity of what that should warrant what should be our concern. The question is the constitution being strictly followed? Now, I don't think the constitution will contemplate any harm to the judiciary by providing for the removal of justice. No. I think we are thinking inconsistently with our intentions for adopting for ourselves the Constitution and inconsistently with the provisions of the Constitution. Because once the Constitution has made provision for the removal of the Chief Justice, it means that it contemplates also that the removal of the Chief Justice for whatever reason stated in the Constitution is not a harm to the independence or any aspect of judicial efficiency, but rather a positive outcome, a positive occurrence that should improve our democracy. But if people are thinking that the removal of a Superior Court judge or a Chief Justice is in itself an attack on the independence of the judiciary without more, it becomes worrying. So the question is, why would the Constitution make provisions for the removal of a Superior Court judge? I don't think that occupying any office in government or of state is a carte blanche for doing whatever you like. And the Constitution is clear about it. That, okay, it has made provisions for the independence of the judiciary, for instance, and has made provisions for the independence of the Chief Justice. Their salaries are charged on the consolidated fund. And apart from the Auditor General, no one can question the administrative expenses of the judiciary. And so many other things, intending to protect the tenure of office. But it also went further to say that with all these things, if a Superior Court judge of the Chief Justice misbehaves or demonstrates incompetence in the office, or has at any time demonstrates inability to perform his or her function in the office due to mental or physical disability, then he or she should be removed from office. How can this be an attack on the independence of the judiciary? The question we should also be asking is, what are the grounds, first, based on which a prima facie case is established? Two, what is the gravity of the things stated in the petition? Or what is the content of the petition? And what's the gravity of the things alleged? What is the evidence in that regard? And what is the pedigree or the competence of the people who have established the prima facie case? If we are satisfied with all these things, then we will not have any cause to say that or to attribute any negative outcome to the process when we have not cited any provision of the Constitution or any provision of any law against which the actors have done anything. You see? And now I want to believe that I want to still believe that the content of the petition are still confidential. I have seen speculation, purporting to be the content of those petitions. But to me, I think we shouldn't take everything lock, stock, and barrel. You see, we cannot just say that, okay, what we have seen in Constitution, and even if that's the case, even if what we have seen is what the president has received as the petition for the removal of this, we cannot assume that that is all there was before the president and the Council of State at the time of establishment of prima facie. Now the suspension of the teachers. The question is, what is anyone alleged against the suspension of the chief justice, apart from some unexplained idiosyncratic feeling that, oh, this shouldn't have happened? I mean, we don't govern a country like that. Your feeling that, oh, this is so egregious, it shouldn't have happened, is not the way to think. It is to understand the process. First, question yourself, why has the chief justice been suspended, and based on what law has he been suspended? Article 146 has given the authority, the president, to suspend the chief justice if he establishes a prima facie case against and then refers the matter to a committee for further inquiry. That's what Article 146 Clause 10 says. And you see, this usually is to give. You see, this is when such allegations are made against no less a person than the chief justice. You see, especially that it is not just one petition. Okay, there are a lot of petitions, and we all know the functions and the duties of the chief justice on daily basis. Now, these kind of petitions will definitely draw a lot of energy and attention of the chief justice. That might affect the efficiency of her function in the office. That's one. And so the suspension is to give her time. The suspension has not taken anything away from what she's entitled as a chief justice, as far as I know. It has not done anything to her. So apart from giving her time and resources and energy to face her allegation. So if this alone does not constitute sufficient ground for the chief justice to be excused, then what else? And let people not think that the suspension is an outright dismissal. No, the suspension of the chief justice is just to hold off her function until the end of the inquiry of the committee. And if the committee finds that she is not guilty of those allegations, as she strongly believes, then of course she resumes her office without any harm whatsoever. No reduction in her remuneration, no effect on her terms of conditions whatsoever. So the suspension, I don't see what is wrong with the suspension. And let's see, historically, we have had attempts made against the removal of chief justices. This is not the only process. Okay? So, are people who think that the Article 146 is just for the optics, it's just for aesthetics reasons, and that it shouldn't be applied? Why were they not speaking at the times when these attempts were made against other chief justices? And let's not politicize the removal of a chief justice. When Justice Aqua was being removed, he was being removed in the regime of the person who appointed him. So, and we have had a president who has worked with a chief justice whom he hasn't appointed. President Mahama has worked with Georgina Wood throughout his term. Professor Atta Mills has done so without making an attempt to remove that chief justice merely because he was appointed by a Kufuor. So when this thing is happening, we shouldn't think that it is partisan or it is political. And so we see but the argument and the passion with which the other side of the political divide is advancing against this process is making it look more partisan and political. You see?
But they are of the opinion that there's no way you can take away the partisan political aspect of it, because this involves a president elected into office who was not the one who appointed this chief justice. They are also saying there were comments made during the campaign period that convinces them that this is a grand agenda.
Yes, that's what I have just said in less than a minute ago. This very president has worked with a chief justice whom he has not appointed throughout his last term. And he never made an attempt, or no attempt has ever been made to remove him. Secondly, the petitions that are presented to the president are usually not petitions that are created by the president. These are petitions submitted by citizens. You understand? And in this case, you cannot associate any of the citizens with the ruling party. Though in other situations, we have seen that the petitions that were made against chief justices or people to be removed from office were members of the other side. For instance, the chair of the Electoral Commission, who was to be deemed, or he is normally to be deemed as a superior court judge, was removed upon a petition of someone we know or people we know to belong to the other side of the divide. But we didn't see that as partisan politics, especially those who are speaking now. They didn't see that as partisan politics. And that's why I'm saying that because this president has worked with a chief justice, and we have had an attempt at removal of a chief justice in a regime of the person or the president who appointed him, and that's Justice Aqua. Justice Aqua was being attempted or was being removed but in the regime of President Kufuor who appointed him. So would we say that this was partisan? So I want us to take off our partisan political caps and look at the process and actually wait to see the real content of the petitions, the real allegations, factual allegations and evidence alleged against the Chief Justice, and to question ourselves whether what allegations they have made amounted to stated misbehavior, whether they amount to incompetence, or whether they amount to any of the conditions stated in the Constitution to warrant the removal of a Chief Justice. That's what we should be doing. If we find if anybody finds whatever he finds as the content of the petition, the question he should ask himself is if this is the real content of the petition, does it constitute stated misbehavior? Now, if he says no, it doesn't constitute stated misbehavior, then they should tell us what the Constitution means by stated misbehavior or incompetence. It is as simple as that. If you don't think A is misbehavior or incompetence, then tell us what it is. Otherwise, the Constitution has made provision for the removal of chief justice based on stated misbehavior and incompetence. And that is what we should be looking at.
But you're seeing,
and no one should think that Article 146 is just for the purpose of, or is superfluous. No provision of the Constitution is superfluous, and this is made clear by the Supreme Court in Ghana Lottery Authority and Attorney General, I think.
You're senior at the bar. I think you're very senior to many of you at the bar. Samuel Okujeto is of the opinion that this is the suspension of the CEO is a fait accompli, that the president has embarked on a journey of no return. That once he suspended the Chief Justice, there's no way he's calling the Chief Justice back.
And on what basis has he made this statement? On what basis? Now, which part of the Constitution or which law accepts that once a president suspends a Chief Justice because a prima facie case has been made against her and a matter against her has been referred to the committee contemplated in the Constitution, will never return to the office of the Chief Justice? I think people are talking about things they know that we don't know. Perhaps they know things we don't know. But if we look at our law, there is nothing that prevents a Chief Justice from returning to office after the suspension of the president. Even in fact, the president can at any stage revoke the suspension himself and return the Chief Justice to that office.